The Eastern Cape Premier will be going back to work, and that's the word from his legal representative, Ngqiqo Sakhela. The Bhisho High Court has ruled in favour of Mabuyane and the MEC of Public Works and Infrastructure, Babalo Madikizela. The ruling follows an urgent application made to suspend the enforcement of the remedial actions of Public Protector Busisiwe Mkhwebane against the pair. The remedial action stemmed from the Public Protector's investigation into the 1.1 million rand from Winnie Madikizela-Mandela's memorial service.
It was too prompt, but what it means is that our client has been given a space wherein he is going to concentrate on the government work and also on his organizational work, because he has been granted an interdict against the implementation of the report by the Public Protector or her office. Secondly, the interdict has also been granted suspending the implementation of the remedial action.
For more on this, I'm joined now by the Public Protector Busisiwe Mkhwebane's spokesperson, Mr. Oupa Segalwe. Dr. Segalwe, good to have you with us on the daytime update today. Give us the reasons why the judge allowed this prosecution of stay or the non-implementation of the recommendations of the Public Protector.
You may recall that when it was announced that the Premier and the MEC are going to be approaching the court with a two-part application. The first part, which is what has just happened now, the pair asking the court to suspend the implementation of the remedial action by way of an interim interdict. The Public Protector did not oppose that part of the application, because as an institution, we are the ones who are always encouraging those who want to take the Public Protector to review, to not stop at the level of a review application, but also add another part to that application, which is the interdict, so that they are not seen to be ignoring the directives of the Public Protector. Because you recall the Constitutional Court says the Public Protector's remedial action can only be set aside by a court, which means absent a court decision setting aside the report, the remedial action remains binding. So to bypass that, you must go to the courts to secure an interdict, and that's what we have encouraged everyone to do, and they did in this case. Hence, we did not oppose that matter, and this is not the crux of the issue. The crux of the issue will come at the point where the findings are reviewed before court, and that is still going to happen at the later stage. What happened today was applied for on an urgent basis, which is why it took place now, but it's not a review of the findings. The court was just dealing with the authorities which the Public Protector directed to take action on the basis of the findings, to say, hold your horses until such time we have dealt with the review of this particular report.
That's what you say, Mr. Segalwe. When we spoke to Mr. Sakhela just a short while ago, he said one of the reasons why the judge did put the implementation of these recommendations aside is, he says, that the Public Protector based some of her findings on statutes that did not exist. Talk to us about that and where that could be coming from then, if this has nothing to do with a review of the findings or the credibility of the report that the Public Protector has put in place.
Well, we are not aware of that. What I'm saying is that the court would not have dealt with the merits of the report at this point in time, because the review court is yet to hear the case. What was before the court was the issue of suspending or staying the implementation of the remedial action pending those review processes, which we don't know when they will take place. So, which is why the Public Protector did not contest that part. We have always been upfront with it that we will not contest that part, because in any event, we are the ones who encourage you to take that step so that you are not seen to be ignoring the directives of the Public Protector.
One of the recommendations made by the Public Protector was that the Hawks go ahead and investigate this particular case. What danger is there, or what are the disadvantages of the Hawks going ahead with the investigation, even pending the review of this case?
Well, if the court has made a ruling to the effect that those organs of state that ought to take the matter forward must hold their horses pending the review, those organs of the state, including the Hawks, will have to comply with the court order. And they do not suffer any prejudice if they hold their horses until such time the matter has been dealt with in the review court.
What then is the way forward from here, Mr. Sakhela? The next point is a review and the application for this report to be set aside.
Yes, the next step now is for the review court to deal with Part B of the applications of both Mr. Mabuyane and Mr. Madikizela. That's where the crux of the matter is, to say whether or not the Public Protector did a thorough job. That will be decided at that stage of this whole litigation. But at the Office of the Public Protector, we are confident that the Public Protector has exercised her duties and exercised her powers and executed her duties in line with the Constitution and the law.
Mr. Sakhela, thank you for that update. We shall then await a date for when that will move forward.